This is why you should not tell the bank immediately when your loved one dies. This advice may sound counterintuitive, but it's important to understand why you shouldn't rush to notify the bank immediately when a loved one passes away. To be clear, this doesn't mean you should never inform the bank, just that it doesn't need to be your first priority in the immediate aftermath of a death. In the days following a loved one's passing, your primary focus will naturally be on arranging the funeral and allowing yourself time to grieve. These are crucial steps in the process of saying goodbye, and it's important to give yourself space to breathe and process your emotions. You'll have numerous responsibilities to handle in the coming weeks, so it's beneficial to take some time to gather your thoughts and prepare for what lies ahead. During this initial period, you can start collecting necessary paperwork without immediately notifying financial institutions. This includes locating and securing the will and any trust documents, as well as gathering financial statements, bank statements, and other relevant documents. If you're not the designated executor or trustee, it's not your responsibility to notify anyone. That task falls to the person appointed to that role. Once you've had some time to grieve and develop a plan for managing the affairs in an orderly manner, you can then consider notifying the bank. It's crucial to have a clear strategy in place before taking this step. Remember, under no circumstances should you attempt to remove money from your loved one's bank account after they've passed away, as this can lead to legal complications. Ideally, your loved one would have left behind a comprehensive list, including the details of their life insurance policies, financial and banking institutions, individuals who handle their financial affairs, and information about utilities and mortgage companies. This kind of preparation can significantly simplify the process for those left behind. As a helpful resource, we offer a free book, When a Loved One Dies, a Legal Guide, which you can find on our website. When you do notify the bank of the death, be prepared for the account to be frozen immediately unless it's owned by a trust. You'll need to provide a copy of the death certificate and the will to prove executorship. If the account was jointly held, it typically becomes the property of the surviving account holder instantly. While this arrangement can bypass probate at the first death, it may lead to other issues such as potential tax implications or family conflicts. For instance, siblings might resent one child receiving all of the money from a parent's account if they were named as a joint owner. By approaching these tasks thoughtfully and in the right order, you can make the process easier to manage during an already difficult time. Remember, taking care of yourself and your immediate family should be your first priority, with financial matters handled carefully but not rushed.